Sir, please, sir, by all means, by request, sir.
So everybody is, the link is established now, Mr. Sharma.
Yes, sir.
Can I start?
Yes, sir. Please, sir.
Okay. Good evening, and good evening, Vibha.
Manoj, how are you?
Fine, thank you. Uh, Vibha Makhija is here, senior advocate, and welcome to everybody. And sorry for the delay. This is delay on our part. So welcome to this lecture, small lecture on procedure and practice. Now, this is a very important part of the advocate on record examination, because this is your guide. This is unique amongst all the other papers, because this is a walk through the Supreme Court. You need it essentially at
No, sir, I'm sorry to disturb. Your voice is very low, sir. If you can please come closer to the mic, sir.
right. Is it okay now? Is it okay now?
Yes, it's okay, sir.
Right. This is the importance of this paper is immense, because you will need, as an advocate on record,
Still not audible, sir. It's very low, sir.
this is the maximum voice here. The maximum voice. But I can hear you.
Maybe they
Sorry.
maybe they can increase the voice from the technical side.
Yeah, please do. Mr. Sharma, just kindly see now.
Sir.
Everybody, is my voice audible to you?
Sir, voice audible?
Yes, I
Low. A bit low, sir. A bit low.
Is it going? Is it low, Vibhaji, on your side also?
no, I can hear you clearly. Maybe everybody can increase the volumes of their own systems.
Yes, maybe that. Maybe that. Mr. Sharma, at your end, you're saying the volume is low.
Now it's fine, sir.
All right. So this procedural practice is a very important part, as I was saying, because you need it as practitioners of this court at every stage. So this is the importance of this paper. And while you are preparing for this, you are preparing also to be advocates on record of this court. Now, we would suggest that you concentrate on the Supreme Court rules 2013, and you concentrate on the handbook of procedure and practice, which was published by the Supreme Court in 2017. Now, these two books will guide you through. I'll briefly introduce you to these, and you can read through in details. Now, when you take the Supreme Court rules, you would find that it gives you the business of the work that is transacted in the chambers of the honorable judges, the constitution of the division benches, how affidavits are filed, how inspections are taken, all things, how decrees are prepared here, what is a copying branch, how do you apply. All these things are mentioned here in the Supreme Court Rules 2013. We had the earlier rules to Supreme Court Rules 1966, which were revised to a great detail, and then we came up with Supreme Court Rules 2013. Then it would give you the appellate jurisdiction of the court, the various appellate jurisdictions which will be asked for, which are part of the syllabi, and you need to know about this, the criminal appeals, the civil appeals, and then the appeals under the special acts. Just a brief introduction. The election petitions, the original jurisdictions, the appellate jurisdictions of the court, that the requirements of a review petition, requirements of curative petition, what are costs, and what are the requirements for translation, the procedural aspect of it. Now take a brief look at the handbook of practice and procedure called Supreme Court of India Handbook on Practice and Procedure and Office Procedure. That's the full name, 2017. Now, this again gives you this is again very brief on every topic, but it introduces you to the topics, which is of great help to a practitioner of this court. This is unique to this court, the Supreme Court. So advocate on record, advocate, it defines. And then the court and this court particularly, court fees, interlocutory applications to be filed, miscellaneous applications to be filed. These are applications. And then it will give you the court and the jurisdiction, the appellate jurisdiction, the extraordinary appellate jurisdiction, the original jurisdiction. Civil suits are filed, government to government, which you've been reading now, government of so-and-so state government versus central government, advisory jurisdiction, inherent and plenary jurisdiction. And then you have chapter 3, for instance, where specific topics are dealt with, classification of cases. That is the contempt petition, election petition, original suits, essential requirements of this, the essentials of a review petition. What are the essential averments required to be made, essential annexures to be enclosed with the review petition or with the curative petition. And then you have, for instance, again in chapter 4, constitution and jurisdiction of the benches. Which matters would go to single bench, which matters would go to division bench, when matters are taken before the constitution bench. Goes on. So what I'm trying to emphasize is that you need to look at both these documents, both these preparations, the Supreme Court rules and the handbook. Now, what I would recommend to you is that that what we are expecting in the answers is a to the point brief answer. So and there may be various parts, so please answer each part, and as far as possible answer point wise. It's far better for you and for the examiner as well. More convenient to read and more convenient to answer. And also to check for the examiner. Please concentrate that the paper and when you do so, then you are sure to finish the paper. That also assists you to finish the paper. Some of the questions, and in many of the questions, a practical approach, because practice and procedure, a practical approach while answering. When you are given a particular situation, how would you handle that in court, keeping in mind the procedure and practice that you are aware of from these two booklets to which I have introduced. This is how I would look at it, would recommend to you to consider. My learned colleague, Ms. Vibha Makicha is here, senior advocate, and she would now share her views with you. Please, Ms. Vibha.
Good evening, everyone. Welcome to the lecture series. And before I start with the course content, let me wish all of you a very, very good luck I hope all of you do very well in your paper. So what I have done for you is that I have made a PPT which will walk you through all the various provisions that we will be looking at. And as Mr. Swaroop told you, that when we are looking at practice and procedure, we are actually walking through the corridors of the Supreme Court, because every aspect of uh, the practice of the court and what is the procedure of the court is what is taken care of in this paper. So essentially, you would be looking at, you can note this down, the statutes, etc., that you will be looking at. Essentially, you will look at, firstly, of course, the Constitution, which basically defines all the various jurisdictions that are there of the Supreme Court. Then you will look at the Supreme Court rules 2013. So these are mandatory, material that you must have. Then you will also have to see the Contempt of Courts Act. You will have to see parts of various statutes which provide the appellate jurisdiction to the Supreme Court. You will also possibly need to so these are the basic statutes and constitution that you need to look at. So we'll start with sharing my PPT. Inder, can you just put on the PPT on the screen, please? And after the lecture is over, I will let you know the email ID of my office, and that can share the PPT with you online as well. Okay, so let's start. And let us start with the heart and soul of the Constitution of India, which is Article 32. Just move on to the next screen. Yeah. So Article 32, as everyone knows, Baba Ambedkar had also said, is the soul of the Constitution of India, because that is what provides a citizen or even a non-citizen the remedy under the Constitution to effectuate their fundamental rights and other rights. So Article 32 is very important. You have to know what are the aspects of Article 32. So the first aspect of Article 32 would be the jurisdiction under it. So what is the jurisdiction under Article 32? It provides the remedy for enforcement of rights under the Part 3 of the Constitution of India. Just 1 second, I'm just trying to bring up on my own screen. Anyways. So we have fundamental rights in Part 3. The tool by which we enforce those rights is Article 32. And the right endures to the benefit of citizens, non-citizens, corporations, etc., to move the Supreme Court by appropriate proceedings for enforcement of their rights conferred by the Constitution, and particularly Part 3 of the Constitution. So you will have to understand that in what circumstances can you approach the Supreme Court directly, because Article 226 also gives the jurisdiction to high courts to enforce the fundamental rights. So you will have to study as to what is the difference between Article 32 and Article 226, what are the limitations of Article 32, whether you can always directly come to the Supreme Court to enforce your fundamental rights, or you're first supposed to go to the High Court, look for your remedy there, then come to the Supreme Court. So Article 32, the basic bottom line is that you can enforce your fundamental rights under Part 3, under Article 32. However, Article 226 is a much wider jurisdiction. you can enforce your fundamental rights, legal rights, rights arising out of statutes, anything where you have you are enforcing in the public zone. So 226 is much wider. 32 is more limited in the sense that you can um, enforce only fundamental rights, and the Supreme Court is reasonably strict about that, and they do reject petitions which come directly to the Supreme Court where the same right could have been enforced in the High Court. The other aspect of Article 32 relates to the scope of 32. The other reason why it is the soul of the Constitution is because this is what also provides for the powers of judicial review. Now, as everyone knows, I hope by now all of you know, that judicial review is a part of the basic feature of the Constitution of India, which you can relate back to Keswanan Bharti case, where the basic structure doctrine was enunciated by this court, which stands strong and good even to this day. And in my opinion, Keswanan Bharti is actually the whole edifice of Supreme Court, because I don't think globally we've had this kind of clarity on what is the scope of the Constitution and how strongly it can be enforced. So Keswanan Bharti lays down the basic criteria of what cannot be interfered with in a constitution. In other terms, what cannot be amended. So the power of judicial review is very, very core to our constitution. And the reason why it is basic is because of the theory of separation of powers, where the judiciary has the power to review all administrative actions, executive actions, and legislative pieces of legislative statutes. So the not just the Supreme Court, the High Court as well, the judiciary has the power to judicially review all the actions of the government and the legislature, and is the final word on what is constitutional piece of legislator or what is constitutional administrative or executive action. So that being the uh, basic feature is contained in your Article 32. Now, under Article 32, the remedy, scope of remedy, when we talk about what is the scope of remedy, the scope of remedy is extremely wide. It is starting from what would be immediate remedy, immediate harm, making good the harm that has been caused to a citizen. And it can range to various aspects in terms of directions to the government, suggestions to the legislature to make law. Like in Vishaka, you had the courts filling in the vacuum where there was no law. They filled up the vacuum in law and made several suggestions to the legislature to come up with law. So in Vishaka on sexual harassment at workplace, then in TMA5 with regard to admissions to professional colleges. So, various cases, the Supreme Court has gone ahead and given suggestions to the legislature, recently in the 377 case as well. So, but it cannot force the legislature to enact certain laws, and it fills up the vacuum by issuing directions in its judgments. So Article 32 is, one can say, a very, very strong part of the Constitution. And as you can see on the screen, you can see the various parts of Article 32. And then basically you also will look at Order 39, 38, Rule 1 to 13, which deals with Article 32 petitions, the format of the petitions. So what I will suggest all of you to do is to look at the substantive aspect, which you will find in the Constitution. Then you will find the procedural aspect, which you will find in the Supreme Court rules. And finally, you will back it up with case law to explain how the Supreme Court has viewed these provisions and what is its interpretation on it. So I would suggest in the long answers, especially, you must have three parts to your answer. This is a general tip for every answer, which should have the substantive statutory or constitutional provision, which should have the procedure which you will find in the Supreme Court rules, and finally, how it has been explained by various precedents of the Supreme Court. Those cases should be referred to, whether you refer to them in detail or whether you refer to them just in short, that would depend on the time that you have. But we expect these three parts to your long answers. Moving on to the next screen, a part of Article 32 is also, Inder, can you just move to the next screen, please, of the PPT? Is also public interest litigation. Now, public interest litigation is a very unique jurisdiction of the Indian Supreme Court. World over, whether it is the American Supreme Court or many other countries, none of the Supreme Courts exercise a public interest jurisdiction, which is almost a suo motu jurisdiction. It falls under Article 32 because it is used to enforce the fundamental rights. But the core of this jurisdiction is the locus of the party who approaches the Supreme Court. So every statute and the Constitution provides the locus of a party who can approach the court. So the rights, for example, appellate rights will inure only to the benefit of the parties which were parties in the original side. So you always have a restriction in terms of the locus of a party to approach a court for a particular relief. Only if the party meets a particular parameter and criteria, depending on the constitutional provision or the statutory provision, can the party move the court for a particular relief. A meddlesome interloper cannot move any court for any relief as such. So the locus being a technical part, the Supreme Court uh, in the 1980s, specifically Chief Justice P.N. Bhagwati, expanded the scope of the jurisdiction of the Supreme Court itself and came up with the jurisdiction of public interest litigation given the peculiar socio-economic condition of the Indian populace. So, especially for weaker and marginalized sections of the society, it was recognized by the Supreme Court that they do not have the uh, resources to be able to move to the court and seek remedy for themselves. So somebody who acts in their interest, provided that that person establishes her bona fides and genuine taking up of the cause of that particular section, that person was awarded the locus to approach the court on behalf of the weaker and the marginalized sections of the society. So the scope being expanded to such a large extent, we have a very rich culture of public interest litigation, and a large number of cases have had a very, very deep and pervasive impact on the Indian society. A lot of progressive views have come forth through public interest litigations, and a large number of ills have been weeded out by way of this part of the litigation. So you will see on this slide that S.P. Gupta was the first case where Justice Bhagwati expanded the scope, and then the Supreme Court also entertains PILs directly, and basically what is the scope of PIL, what reliefs can be given in PIL, etc. You will have to see all the case law on PILs, where the Supreme Court has exerted its jurisdiction to grant relief, or where it has rejected to exercise its jurisdiction. So Order 38, Rule 12, I would emphasize on, is the procedure and the parameters that a PIL litigant has to meet in terms of filing a public interest litigation. So this Order 38, Rule 12 gives the technical and procedural aspect of how you can approach the Supreme Court for a public interest litigation. So kindly definitely look at that rule. Then we come to various other jurisdictions. Inder, can you just move on to the next slide? So the Supreme Court has various jurisdictions, whether it is provided for in the Constitution and otherwise, but specifically different types of jurisdictions. Now, a writ court, a constitutional court, is a court of record. So the Supreme Court and the High Courts are courts of record. And under Article 129 of the Constitution of India, the Supreme Court has the power to issue contempt against persons who are in contempt of its own orders. So you will kindly look into the contempt jurisdiction of the Supreme Court. What is the scope of the jurisdiction? What is the provision under which the jurisdiction is exercised? And whether it is read with the Contempt of Courts Act, you will kindly see that it is read along with the Contempt of Courts Act. And there is a jurisdictional distinction between Article 129 and various provisions of the Contempt of Courts Act. So kindly analyze that a little minutely and see how the contempt jurisdiction is an original jurisdiction of the Supreme Court, and how it is distinct from the appellate powers under the Contempt of Courts Act. Okay. And then we have given some case law for you to go through, which will explain to you what is the scope of extent of the contempt power of the Supreme Court. And you can also see the last bullet with regard to the procedure of moving to the Supreme Court under the contempt jurisdiction. Let's move on to the next slide. Which is the transfer jurisdiction of the Supreme Court. So you have various provisions under which matters which are sub judice in lower courts can be petitioned to be transferred to the Supreme Court. So in certain peculiar circumstances, they can be asked to be transferred from one high court to the other high court, or it can be asked to be transferred to the Supreme Court. And the slide provides you the various jurisdictions which are there. You can also kindly look at what is the distinction between these various transfer jurisdictions. Also, under what circumstances you can move under various provisions, and what is the distinction between the criminal transfer power, the civil transfer power. So kindly maintain that distinction, and also kindly remember the provisions under which you can distinctly move for transfer of criminal matters or civil matters. The one principle of transfer is that the constitutional courts can also transfer by their own motion matters which are pending in the lower courts. Specifically, the Supreme Court can do that under Article 139A, and which is to be read with Order 40, Rule 1 to 10. And they can ask matters which are pending in high courts to be transferred to their own, to the Supreme Court itself. The underlying principle being that if there is a question of law which needs to be decided, and that question of law has been raised across various jurisdictions, then, rather than having multiplicity of proceedings and a large application of judicial time with regard to the same question of law, the Supreme Court may consider it prudent and expeditious to transfer all those matters to itself and to decide it in one case itself. So that's the transfer jurisdiction. Then we move on to the next slide, which is the appellate jurisdiction of the Supreme Court. Now, you will focus on Articles 132 to 136, and these are various appellate powers of the Supreme Court. And in the appellate powers, basically, Article 132 provides that is the appellate jurisdiction of the Supreme Court in appeals from high courts in certain cases. So basically, there are several conditions which are provided under Article 132. Please kindly look at what are the specific circumstances, because the right of appeal is always a very limited right. When the right of appeal is given, you have to see under what conditions the right of appeal can be exercised. So kindly go through Articles 132 to 135 minutely, and please make notes under what condition the appellate jurisdiction can be exercised. Now, 136, Article 136, specifically all of you working in the court for more than 5 years now, understand is a very, very wide article. And this is the special leave jurisdiction that the Supreme Court has. And you will kindly note that Supreme Court has this unique power to exercise to grant special leave to appeal against any order of any court. So in certain circumstances, you can even come to the Supreme Court from a trial court's order. You can come from an interim against an interim order. You can come against a final order. But having said that, having given the wide scope under Article 136, when you will read Article 136, it says any order of any court. So it can be from the lowest court to the highest court of the state, where you can come to Supreme Court and seek special leave to appeal against that particular order. So Supreme Court has that power to grant special leave to appeal against those orders. And you will also see that although the power is so wide, but the court always maintains what I should say, self-discipline in exercising this power. So because this power, and one of the key words here, is a discretionary power, this power is not exercised randomly. There are rules where the courts have where the Supreme Court has imposed self discipline in exercising this power, and there are various situations in which the Supreme Court will not exercise its power. So, for example, if you come against an interim order usually Supreme Court will not exercise its power until and unless there is egregious, violation of some right of natural justice or something like that. Secondly, Supreme Court also refuses to exercise its power in cases where you come directly against lower courts without going through uh, various other levels of the hierarchy of courts. So kindly see in the uh, jurisdiction which is exercised by the Supreme Court under this article, it being extremely wide, what are the self-imposed restrictions that it applies to itself? So let's move on to the next slide. Now, with regard to appellate powers, besides in criminal proceedings, besides the power given under CRPC, Article 134(2) also, if I'll just read this, Article 134(2) provides that Parliament may by law confer on Supreme Court any further powers to entertain and hear appeals from any judgment, final order, or sentence in a criminal proceeding of a High Court, subject to conditions and limitations as may be specified in law. So, in pursuance of this power, the Supreme Court has promulgated the Supreme Court Enlargement of Criminal Appellate Jurisdiction Act 1970, under which, uh, besides CRPC provisions, you can also approach the Supreme Court in an appellate jurisdiction on the criminal side. So kindly look at this aspect also and Order 20 of the Supreme Court rules. And essentially, a certificate is usually required from the High Court to move an appeal against a criminal decision. But under the enlargement of the jurisdiction, that requirement is done away with. Then let's come to the next slide. The Supreme Court also exercises original jurisdiction in large number of areas. So Article 131 confers the power to adjudicate disputes between governments. So it can be a state government versus a state government. It can be a state government versus the union government. So basically, suits which are instituted by government against a government are adjudicated directly in the Supreme Court. They don't have to go to civil courts and start from the trial court. These are directly instituted as suits. So, like all the CPC provisions with regard to suits will apply to these proceedings. These suits are directly filed in the Supreme Court. Supreme Court has the original jurisdiction to entertain suits between government of India and one of its states or between the states themselves. So you will examine what is the scope of Article 131 and how it is similar to original suits in civil courts, and what is the small distinction that is there between a suit in the civil courts versus of private litigants versus of the states. Then let's see one important aspect of 131, which is the proviso to 131. Now, this says that the jurisdiction of Supreme Court does not extend to a dispute arising out of a treaty, agreement, covenant, engagement, or other similar instruments. So essentially, the power of the Indian government to enter into treaties, covenants, etc., with foreign countries or uh, with their own, with, for example, at the time of independence, the government of India entered into several covenants with sovereign states, the provinces, which were existing at that point of time, to make them accede to the Indian Dominion. So, at the Privy Purse cases, Those were the covenants which were signed between the Indian government and the provincial state sovereign rulers to make them accede to India. And those covenants have various uh, covenants contained within them, which are applicable between the Maharajas of those states and the Indian government. And with regard to those, or with regard to any international treaties or agreements, no suit will be entertained by the Supreme Court of India. And those covenants, agreements, treaties are beyond the pale of judicial review or adjudication by the Supreme Court. Then let's move on to the next slide, which is Article 141, which is the power of the precedents. And Article 141 is a very powerful, what should I say, article. It provides that the law which is declared by the Supreme Court is the final interpretation of law. So the legislature may enact a particular provision, but its interpretation, how it has to be interpreted, its constitutionality, the final word on that would be that of the Supreme Court. And those decisions would be applicable to all high courts, and they actually get a legislative flavor to it, and they are then the law of the land. So a precedent becomes the law of the land, and it is something which has to be applied across all courts in India. So you can just see these cases which we have set out for you on the scope of Article 141. Then comes Article 142, which is again very wide in its scope and which is also unique to the to the Supreme Court. This power is not contained with regard to any high court or any lower courts. So the power to do ultimate justice, complete justice between parties, whether they are private or government parties, is there with the Supreme Court. And despite statutory restrictions, Supreme Court may pass certain directions which would end up doing complete justice between the parties, but which may be contrary to a statutory jurisdiction. So, for example, relief may be limited under a particular statute, but that relief can be molded or expanded by the Supreme Court to do complete justice in a particular case. So I would say that the power of the Supreme Court to grant divorce under Article 142. Now, this is not a power which is contained under any statute, Hindu Marriage Act, or any other divorce act or anything, but it is a power which the Supreme Court exercises to do complete justice between the parties. So kindly look at the scope of 142, that despite statutory restrictions, Supreme Court holds a very, very expansive and wide power to do complete justice in several situations, and you will find them in several cases. Then is the advisory jurisdiction of the Supreme Court. The president can, at any point of time, invoke the jurisdiction of the Supreme Court to get advice on how a particular constitutional provision is required to be interpreted. And there are a large number of constitutional situations that arise. So the president has the power to refer those issues. This will not be, so there's a contradistinction between dispute and issues. So kindly be careful that Article 143 is advisory jurisdiction. It is not a resolution jurisdiction. It is not a jurisdiction where the Supreme Court resolves dispute between two parties. It is completely advisory. It is not binding. It is something which is only in the realm of a of an advice, a suggestion, a reading, and an interpretation. It is not binding on the person who has sought the advice or on any other party. So it is purely advisory, and it's only in constitutional crisis that the president usually invokes this remedy which is available to them, to her, and invokes this power of the Supreme Court. So you will kindly look at what is the scope of the advisory jurisdiction and what are its restrictions. Then comes the review jurisdiction, again, something which you would be fairly familiar with practicing in the court, because when you're disappointed with the final decision, you always try to move a review and hope that the adverse decision gets revised in a review. So again, Article 136 gives the power to the Supreme Court to review its judgments. Then I'm sure all of you are very well conversant with the grounds of review. There are 3 specific grounds of review: that it cannot be in a disguise for an appeal, there has to be an error apparent, there has to be a failure, abject failure of natural justice. So these are the grounds, very limited grounds of review. You can kindly see that review jurisdiction is not for reconsideration, but is only to rectify apparent and gross errors on the face of the record. Then you will see the Supreme Court rules as to what is the procedure of reviews, that they go, review petitions are listed in chambers, usually before the same judges who have given the final decision. So kindly look at Order 47, Rule 125 with regard to the procedure of exercising review jurisdiction. Then we again come to another jurisdiction, like PIL jurisdiction. This jurisdiction has been given to the Supreme Court by itself, which is the jurisdiction of curative petitions. Now, Supreme Court found that in certain cases there has been an absolute failure of justice, and specifically because there has been an absolute failure of natural justice, which is a basic part of the rule of law. And any judicial decision which does not follow the principles of natural justice cannot be considered to be a judicial decision. And therefore, it loses its moral force in application. So, Supreme Court devised for itself the curative jurisdiction. And in the case of Rupa Ashok Hurra, it set out the specific conditions under which a curative petition can be exercised. And recently, Supreme Court has had the occasion to exercise its curative jurisdiction more frequently than it normally does. So usually there are very few cases in which the Supreme Court exercises its curative jurisdiction. There are also restrictions that it has to be certified by a senior counsel. It has to give the grounds why a curative petition has been considered necessary. And in the case of NN Global, where the arbitrator's powers were, with regard to the stamp duty, were decided in the NN Global case, was also then opened up in curative petition. So we see that from Rupa Ashok Hurra onwards, kindly see all the curative petitions. The scope of curative petition has, kind of inched forward in being expanded, and certain new grounds being added to its exercise, because in Rupa Ashok Hurra, and it doesn't, it says in these specific conditions or in case of other gross miscarriage of justice. So now the Supreme Court is expanding its jurisdiction of gross miscarriage of justice. And you will find in the more recent cases of curative petitions where the Supreme Court has exercised its power beyond the grounds which are provided in Rupa Ashok Hurra. Then let's move on to the next slide. I will not spend too much time on it. You please kindly go through this. There are various statutes under which appeals are directly provided. I don't think we have put the IBC provision here. So kindly see all the statutes where appeals are provided for in the Supreme Court. So you'll see in under Customs Act, CRPC, Consumer Protection, Contempt. So just see all the special enactments will normally have the direct appellate power to Supreme Court. So IBC also has, that is not given in the slide. So kindly check up all other statutes also, where the statutory appellate jurisdiction, this is known as the statutory appellate jurisdiction, in contradistinction to appellate jurisdiction, which is provided for in the Constitution. Then various aspects of practice in the Supreme Court are covered under this paper. You will also come across how lawyers have to conduct the practice in Supreme Court. So you might also like to look at what is professional misconduct. And then finally, please do minutely look at the Supreme Court rules. Do try and memorize the provisions, the order numbers, the rule numbers, and I would suggest that you please be very, very conversant with the Supreme Court rules because they are the handbook of procedure. And they are very important for an advocate on record because if you are not conversant with the Supreme Court rules, then your matter will never get approved. You will have to go on correcting the defects and kindly ensure that you go through the Supreme Court rules with a fine tooth comb and you memorize all the provisions which you will feel are more relevant. And because there will be questions, we can tell you that there will be questions from the Supreme Court rules, and don't, treat them lightly. They're a very important part of this paper. So that's the end of this PPT. And with that, Manoj and I, Mr. Swaroop and I will wish all of you a very, very successful attempt at the paper. And if you have any questions, Mr. Swaroop, can you please come online? So if you have any questions, I think you can email them to us. You can write my email down, which is maybe Inder, can you just type into the chat box our email ID? So my office will just share my email ID. You can send any queries to us on that email and we will try and resolve them for you. So with that, wish everyone a very best of luck and wish you all the very best. Thank you.
Yes, and best of luck to all of you from both of us. All the best.
Bye bye.
Thank you, sir. Thank you, ma'am. Thank you, sir. Obliged.